Hello everyone. Welcome to Daily News Decoded initiative of Next IAS. Today I will discuss 5 newspaper articles from The Hindu and Indian Express. The first article will discuss Supreme Court's Diamond Jubilee celebration. In the second article we will discuss Prohibition of Child Marriage Act 2006. In the third article we will talk about Denotified Tribes. In the fourth article we will discuss the concept of parole in the context of Rahim. And in the fifth and the final article, we will talk about Deepseek, the recent venture by China in the space of artificial intelligence. So going by the first article basically discusses Supreme Court's Diamond Jubilee. What is the backdrop of this particular article? Basically, Supreme Court has recently completed 75 years on Tuesday, that is yesterday. And a ceremonial bench of all 33 judges, including the Chief Justice of India, they all assembled to mark the Diamond Jubilee celebrations. Justice V.R. Krishna Iyer, former Supreme Court judge, as we are talking about the Diamond Jubilee celebration of Supreme Court, so we should remember his words. Justice V.R. Krishna Iyer, former Supreme Court, he once remarked that the Supreme Court is not final because it is infallible, but it is infallible because it is final. He said that the Supreme Court is not final because it is infallible, but rather it is infallible because it is final. This famous quote is basically what it underlines. It underlines the court's ultimate authority despite the possibility of errors. When we look into the relevance of this particular topic, it is very relevant from your prelims perspective. Across years, UPSC has been asking questions on Supreme Court, High Court. In the mains part, it is very relevant under GS2 portion of functioning of the judiciary. Now, when we look for the comprehensive coverage of this topic, initially you should know why it was in news, that we have already covered because of 75 years. Second, you should draw the establishment, that how was the Supreme Court of India established. This is the most important slide because you will cover the entire timeline here, starting from its origin, the Regulating Act of 1773 till today. Then you will talk about the constitutional provisions regarding Supreme Court of India. Next, its independence. How are Supreme Court judges impeached? Then there are certain hidden facts which you might not have heard but are very important. Next, we will also discuss certain major judgments of Supreme Court of India. Next, very important slide, major challenges faced by Supreme Court. Yesterday, CJI, Mr. Sanjeev Khanna, he highlighted 3 major challenges that are being faced by Supreme Court. We will discuss those 3 in our upcoming slides. Then we will also discuss the concept of judicial activism versus judicial overreach. These are 2 words which are very often seen in news and you might have heard about them. We will see what are these concepts and where, in which cases, judiciary, Supreme Court of India has basically used these things. Then we will talk about various way forward. Way forward will be in context of the challenges faced by Supreme Court of India. These are certain PYQs which have been asked by UPSC from this particular topic in mains. First article talks about critically examine the Supreme Court's judgment on NJAC, National Judicial Appointment Commission Act 2014, with reference to the appointment of judges of higher judiciary in India. This is very important topic. We will also cover the context of collegium system with respect to this particular answer. The next question was asked in mains 2022. The most significant achievement of modern law in India is the constitutionalization of environmental problems by the Supreme Court. Discuss this statement with the help of relevant case laws. Here you will also understand the concept of judicial activism. Next, when we are talking about the establishment part of Supreme Court of India, we should understand the basic timeline. It basically started with 1774. Why? Because this Supreme Court of Calcutta was established in 1774 under the Regulating Act of 1773. Next, we move forward to 1862. Basically, there were 2 high courts, High Court of Bombay and High Court of Madras. These 2 were established in 1862. Next is about 1935, very important, that in 1935, under the Government of India Act of 1935, this Federal Court of India was established. What Federal Court of India was established, and it basically functioned as the highest court until India got independent. Finally comes the 1950 era, when in 1950 this Federal Court of India Basically on 28th January 1950, just 2 days after India became a sovereign democratic republic, Supreme Court basically came into existence. It succeeded the Federal Court of India, which was established in 1935. And this was established under Government of India Act of 1935, as I have already discussed. So this was the time when Supreme Court came into existence. Next comes 1973. Basically, it was the Keshavananda Bharati case where this basic structure doctrine was basically talked about. Next in 1976, this was another major era for Supreme Court of India. Why so? Because the 42nd Amendment Act of 1976, it made various changes to the Indian Constitution, and basically it also aimed at curbing the powers of the judiciary by limiting judicial review. That it was aimed at curbing the powers of judicial review, right? Then 1980s came the concept of PIL. What is PIL? Public interest litigation. Basically, it was aimed at greater access to justice for marginalized communities. Next is the 1981. It was the first judges cases of 1981. Basically, here it was propagated that consultation by president for the judges, the CJI, it does not mean concurrence, and it only implies exchange of views. Basically, president consultation does not mean concurrence, that whatever will be the suggestion of the president, you don't have to be necessary in concurrence with that, but it can be just exchange of views. Then 1982, basically Supreme Court Legal Aid Committee was constituted to provide free legal aid to the communities. 1993, we had the second judges cases. Second judges cases was about the appointment of judges to the Supreme Court and High Court. It would require a collegium of senior judges of Supreme Court and not just the opinion of the president. Next, we had third judges case in 1998. Basically, this timeline is very important to understand the development, the advancements in the functioning of the Supreme Court. So 1998, you had the third judges case. Here, basically, it was emphasized that the opinion of the collegium consisting of CJI and some other Supreme Court and High Court judges, it would be binding in the judicial appointments. So this was that appointment, it would be binding basically. Then 2014, we had this NJAC Act, which was basically in 2015, it was declared null and void by the judiciary. Why so? It was held in this NJAC Act that executive would also be a part of judiciary. 2020 was the time when we saw the digital transformation, basically adopting e-filing and virtual hearings. So this is where we came forward to digital transformation. This was the era of COVID-19. Next, if we talk about the constitutional role and powers of Supreme Court, you will realize that basically under Article 124 to 147 in Part 5 of the Indian Constitution, it has been talked about regarding the organization, structure and other powers and procedures of the judiciary, right? So Article 124 to Article 147. Article 124A, it basically states that there should be a Supreme Court constituting of a Chief Justice of India, and until Parliament by law recommends, there should be 7 other judges, not more than 7 other judges. This has been transformed over a number of years, and the current strength is 34 including CJI, that is 1 plus 33. Basically, when we talk about the jurisdiction of Supreme Court of India, it has been mainly categorized under 3 categories, that is original jurisdiction, appellate jurisdiction and advisory jurisdiction. Now, what is this original jurisdiction? Original jurisdiction means that Supreme Court for various disputes, it has the original power. That is, certain disputes can be heard by Supreme Court originally without a way of appeal. And it also has exclusive power with respect to those certain disputes that no other court other than Supreme Court can hear those disputes. When we are talking about appellate jurisdiction, so basically Supreme Court also hears various disputes by way of appeal, that certain disputes were going on in some other courts. So Supreme Court can basically take, it can be a primary court of appeal for all those judgments of the lower courts. Third, we have advisory jurisdiction. Basically under Article 143 of the Indian Constitution, it authorizes the President of India to seek the opinion of the Supreme Court in certain cases. The first case is regarding basically when there is a question of law or any other fact of public importance which has arisen or is likely to arise. Second case is regarding any dispute which is arising from pre-constitution treaty. So these are three very important jurisdictions with regard to Supreme Court. Next, when we are talking about other jurisdiction powers of Supreme Court, basically it acts as a court of record. What is court of record? Various judgments, proceedings of the Supreme Court, they are a testimony. They are recorded and can be used as a testimony in some other cases. Second is judicial review. Basically under Article 13, Supreme Court is also having the power of judicial review, where it can review various laws that have been executed, that have been enacted by various executives of state government or maybe Lok Sabha. Then we have revisory jurisdiction. Basically under Article 137 of the Indian Constitution, Supreme Court is subjected to revisory jurisdiction, that it can revise its own certain judgments that were given in the past. When we talk about other powers of the Supreme Courts, it is basically the highest court of law. We know that the structure of the court in India is Supreme Court, then High Court, then subordinate courts. So basically Supreme Court acts as the highest court of law. Next we have its law is binding on all courts of India. Third, it has control over subordinate courts, as we have seen in other jurisdictions also, that it has appellate jurisdiction and other things. Next, when we discuss the independence of the Supreme Court, then the first point that comes to our mind is security of tenure. Basically, once appointed, these judges, they will attain their office until the age of 65, and they can be removed only by a presidential order, or basically various grounds of either you say proven incapacity or basically misbehavior. And this is also not a very easy procedure because it requires a special majority under Article 368. This we will see in our next slide also, where we will be talking about the impeachment of Supreme Court judges. Basically, this shows that they are not at the whims and fancies of president. They are not holding their office for the pleasure of president, right? So this shows their independence. Second thing is salaries and allowances. Basically their salaries and allowances, they are charged on the Consolidated Fund of India. That is, they are non-votable by the parliament, and basically whatever salaries and allowances that they are holding, they cannot be decreased to their disadvantage except during a financial emergency. Third is powers and jurisdiction. Basically parliament has the power to add to their powers and jurisdiction, but it cannot curtail the powers of Supreme Court. Fourth, no discussion on the conduct of judges. Basically constitution, it prohibits the discussion on the conduct of judges either in the parliament or in any state assembly also. And Supreme Court has the power to basically punish for its contempt under Article 129. This is basically to ensure the independence of the functioning of Supreme Court. Next is regarding separation from the executive. Basically under Article 50, it has been clearly mentioned that basically judiciary should be separate from executive, and this was the reason why even this NJAC was struck down. Next, ban on practice after retirement. Basically these Supreme Court judges, they are not allowed to practice in any court or in the territory of India after their retirement. So these all features, they mark the independence of this particular institution called Supreme Court of India. Next, when we talk about the judges' impeachment, basically when we talk about the Supreme Court judges' impeachment, a judge of the Supreme Court can be removed from his or her office only by an order of the president, which is also not a very easy procedure. And the various two grounds are either proved misbehavior or incapacity, right? And the procedure relating to the removal of judges of Supreme Court, it is guided by Judges Inquiry Act of 1968. Now the funny fact is, no single judge of Supreme Court has been impeached so far, not even one judge. But in this reference, we should talk about Justice V. Ramaswamy of Supreme Court in the time of 1991 to 1993. Basically his was the first case of impeachment, though the inquiry committee, basically it found him guilty of misbehavior, but still that particular motion was defeated in the Lok Sabha, so even he was not impeached. Such factual information is very important for you from your prelims perspective. Next, if we talk about certain hidden facts regarding Supreme Court, the first thing that I would like to mention is the only judge who resigned in protest. He was Justice H.R. Khanna. He basically resigned in 1977 after he was not basically considered for the post of CGI. His dissent in the case of ADM Jabalpur, that you should basically read once and drop in the comment box also. At least we will also come to know that you read certain things and you know the basics of ADM Jabalpur case. Next hidden fact is the master of the roster controversy 2018. Basically, there were 4 judges. In 2018, they hold a press conference to discuss then CJI Mishra, basically Justice CJI Deepak Mishra, that how is he allocating various cases. Who were those 4 judges who basically hold this press conference? One was Justice G. Chelameshwar, then second was Justice Ranjan Gogoi, Madan Lokur, and basically Justice Kurian Joseph. These were 4 judges. These very important facts will be relevant for you from prelims perspective. Next is India's first women Chief Justice. We are still waiting for this, and this is again a challenge, a criticism of the Supreme Court of India, that so far India did not have even a single Chief Justice who was female. There were many male justices, but not even a single Chief Justice. And we can see the first Chief Justice from female side in 2027 as Justice B.V. Nagarathan. This is what we are expecting. Fastest verdict just in 4 minutes. Basically, there was a case regarding this movie Justice LLB 2. Right. So this case in 2017 was the fastest case because it was dismissed in just 4 minutes. Then which was the longest constitutional bench hearing? This was Keshavananda Bharti case. This was the longest ever case which was wrapped up in 68 days. So these are some of the important facts that you must understand and remember from your exam perspective, right? Then if we talk about some major judgments, this is again a very important thing because till the time we don't recollect. See, Supreme Court has given so many judgments, but yes, for our understanding basis, we will at least try to cover some 10-15 of them. First was the Keshavananda Bharti case of this 1973, where this this basic structure doctrine was basically propagated. Next was Menka Gandhi case versus Union of India 1978. What was held here? Basically, it expanded the meaning of right to life. Right to life under the Constitution of India. Then next we had this Minerva Mills case of 1980. What was held here? Basically, Constitution and not the Parliament is supreme. It said that it is the Constitution which is supreme and not the Parliament. Court basically said that the balance between fundamental rights and DPSPs, it is the cornerstone of Indian Constitution. Fourth was the case of Muhammad Ahmad Khan versus Shah Bano Begum 1985. This was basically regarding the sanctity of personal religious laws, and it also talked about the concept of UCC, this Unified Civil Code. This is one topic which I have already discussed in one of my D&D shoot. Fifth was, we will also discuss about Indira Sahni versus Union of India 1992 case. This was basically when the constitutionality of reservation was talked about under the Constitution of India. Next was a very important case by the name of S.R. Bommai case 1994. This was the case which basically curbed the blatant misuse of Article 356, that is imposition of president rule in state. Next was another very important judgment in the case of Vishakha versus State of Rajasthan 1997. Here Supreme Court talked about the basically protection of women from sexual harassment at workplace. This was another major milestone. Next was IR Coelho and State of Tamil Nadu 2007 case. This has been asked as a full-fledged question by UPSC in its mains. In this particular case, basically it said even though a law is listed in the 9th schedule of the Indian Constitution, still it can be scrutinized under judicial review. A law by being under 9th schedule does not mean it is debarred under scrutiny from judicial review. Ninth case that we should discuss is regarding Aruna Ramchandra Shanbhog versus State of India, in Union of India in 2011 case. Here basically Supreme Court accepted passive euthanasia being constitutional, passive euthanasia. Then we have this Lily Thomas versus Union of India 2013 case. This is another very important question, very important case, and I think it has been covered by UPSC in the past also. It basically struck down section 842 of RPA 1951. In this Lily Thomas case, Supreme Court struck down unconstitutional as section 84 of Representation of People Act 1951, which used to allow various convicted lawmakers a 3-month period for filing appeals to the higher court and basically get a stay. So in Lily Thomas case, Supreme Court said that this is completely unconstitutional. Then we have this justice case, Puttaswamy versus Union of India case. It was basically regarding right to privacy judgment. That right to privacy is intrinsic to the right to life and liberty. Then we have this Navtej Singh Johar versus Union of India 2018, basically where Supreme Court decriminalized this homosexuality by striking down section 377 of IPC. Finally, we will also talk about Babita Punia case of 2020, where Supreme Court said that in this SSC case, that yeah, women basically they should be allowed, they should get a permanent commission or a full length career in SSC, and it is very well justified. So these were 13 cases which we discussed as basically major judgments given by Supreme Court in recent past. Next is very important topic, that when we are talking about the Diamond Jubilee celebration of Supreme Court, and CJI Justice Sanjeev Khanna, he also discussed 3 major challenges faced by Supreme Court. So we will discuss certain challenges. First is the challenge of judicial pendency. Basically, you should understand the data that as per National Judicial Data Grid, as of 29th January 2025, 82,922 cases are still pending in Supreme Court. So judicial pendency is a very big basically concern area, and Justice Khanna talked about areas in this particular context only. Second is judicial appointment. Basically, first thing is that there is no constitutional status given to collegium system in India. There is no transparency and accountability regarding this collegium system, and this is basically a slap on the people of India. Why? Because there is no transparency. It is the judges who are appointing the judges, and there is no procedure that comes before the common man. Third is allegations of nepotism. You might have heard about uncle judges, that there are various relatives and basically cousins and all who become judges of these judges. Next is a lack of global equivalent. India is the only country where judges appoint judges. So we are basically not having any global equivalent in this particular context also. Third is judicial overreach. This particular topic I will discuss in my upcoming slide also. Basically, this is again a big challenge for Supreme Court. Why? Because Supreme Court is overreacting, over basically reaching its mandate and its power. As we have seen in the context of where Supreme Court basically it made a highway ban, this liquor ban, that 500 meters from national highway or state highway, you cannot have a liquor outlet. Fourth is lack of diversity. This can be seen in the case of gender also, caste also, religion also. And this is reflected in the fact that so far India did not have even a single female CJI. Fifth is accessibility. This was again one major factor that was talked about by Justice Sanjeev Khanna yesterday. He said that accessibility, why? Because of mounting cost of litigation. These are exact words given by Mr. Sanjeev Khanna. Mounting cost of litigation is one reason which is leading to poor accessibility of justice in India, and it has also been highlighted by Law Commission in its 236th report. The report was titled as Court Fees in Supreme Court vis-a-vis Corporate Litigation. It focused on the high cost of litigation in Supreme Court, and that is the reason which is leading to deterrence for the individuals to seek justice. Next is falsehood. Justice Sanjeev Khanna said that justice cannot thrive where and when falsehood is practiced. And Bombay High Court has also basically given a reference to this particular thing in recent times, that false claim by wife against the husband, they are acting as a cruelty even to the family of the husband. So Justice Khanna said that justice cannot prevail when and where falsehood will be thriving. So these are certain challenges. Then we have the concept of judicial activism and judicial overreach. Finally, we will also discuss judicial restraint. And basically judicial activism is, it refers to the idea that judges, they should not actively, basically they should very actively interpret and shape the law rather than implementing it as it was given to them. That you should be very active to understand the legality of a particular law, and you should not blindly go ahead with sanctioning that particular law as it came to you. This was seen in Keshananda Bharti case also, Menka Gandhi case also, Vishaka guidelines also, and Nalsa case 2014 also. And judicial activism is very important for a country like India. But in recent times, we have seen that this judicial activism had turned into judicial overreach, where judiciary is trying to interfere in the work of executive. It is trying to frame those laws which are not under its domain, under its power also, and it's trying to reach into the domain of executive. It was seen in basically this Sham Narayan case where this national anthem was tried to be made mandatory. right? Then we have this liquor ban, as I have already discussed in my previous slide, where Supreme Court said that you cannot have a liquor outlet from this particular distance on state and national highways. Then we have this Arun Gopal versus Union of India case, where it basically banned firecrackers. And we also have this another MC Mehta versus Union of India case, where it said that no BS4 vehicle can be basically sold after a particular date. So these were certain things which were not under the domain of Supreme Court, but they were basically under the domain of judiciary. So this was considered judicial outreach, not judicial activism. Finally comes the concept of judicial restraint. This was basically seen in the Aravali Golf versus Chandar Haas and another's 2007 case, where basically Supreme Court asked the subordinate courts to exercise judicial constraint, and it should respect various organs of the judiciary. That you should exercise judicial constraint and do not basically infringe into the powers of others. When we talk about way forward, basically Supreme Court of India as the ultimate custodian of justice, it must remain vigilant, and basically it should adapt to the ever changing needs of society. Basically by embodying this Sanskrit principle of yatho dharma tatho jaya. This is a Sanskrit principle, and if Supreme Court embodies to this particular principle, the court will not only ensure victory for the justice, but it will also bring the people closer to the ideals of equality and truth. We should very confidently, look forward to the words of Kapil Sibal, as said by him yesterday only, that the power of argument must prevail over the argument of power. That the power of argument must prevail over argument of power. That is why, and this is the only way by which Supreme Court in the 21st century India can show its true relevance. Then we have a practice question for you. Trace the evolution of the jurisprudence in the Supreme Court of India and elaborate how it has been responsive to the conscience of Indian democracy. Try to attempt these questions from mains perspective and try to basically drop your answer in the comment box. It will hardly take 6-7 minutes. If you have basically listened to the this particular shoot, then you can easily attempt these questions based on the info given by us. Thank you. And the next article talks about Prohibition of Child Marriage Act 2006. Why it is in news? It is in news because the Allahabad High Court in 2024, it ruled for equal annulment rights in child marriages for men as well as women, which means that you need to push the uniform marriage age for 18 for men also and for women also. If you look for the relevance of this particular topic from your UPSC main side, under GS1 it will fall under GS Society, and in GS2 it is very important from your social justice perspective. There are certain PYQs that were asked by UPSC in some recent years. In 2016, UPSC asked a question, examine the main provisions of National Child Policy and throw light on its status of its implementation. In Mains 2022, UPSC asked a question, the right of children to free and compulsory education Act 2009 remains inadequate in promoting incentive-based systems for children's education without generating awareness about the importance of schooling. Analyze. Now, when you look for the comprehensive coverage of this particular topic, first you should understand why it was in news, that we have already seen in context of Allahabad High Court 2024 ruling. Then status of child marriage in India, some factual data of NFHS 5. Then reasons for prevalence of child marriage in India, what are the consequences, measures taken by the government. Then comes the major demand of the article, key provisions of Prohibition of Child Marriage Act 2006 and issues there. And finally, what is the way forward, right? So basically, according to this National Family Health Survey 5, it says that women aged 20 to 24 years are more married before the age of 18 years, right? So this percentage is 23.3%. Then when we talk about men who are aged 25 to 29 years and they were married before this age of 21 years, this percentage is 17.7%, right? When we talk about this rural as well as urban divide, so basically in rural areas this percentage is 27% and in urban it is 14.7%. Then it also talks about certain improvement, that from this year 2006 it is decreased by almost 50%. Then 2006 it was 47% basically instances of child marriages, but when we talk about 2019 2021 it reduced to almost 23.3%. Then regional variation is also there in this child marriage thing. Why? This states like Andhra Pradesh, Assam, Bihar, Jharkhand, Rajasthan, Telangana, Tripura and West Bengal, they show higher prevalence of child marriages than the national average. On the other hand, we also have data by this NCRB which says that from year 2017 to year 2021, the cases of child marriages which were reported, they basically kind of tripled from 395 to 1050. This is factual data which will be very helpful while you are writing your mains answers. Next, when we talk about the reasons for the prevalence of child marriages in India, basically the first and the very common reason, the very simple reason that comes to our mind is illiteracy. Why illiteracy is leading to child marriages? Basically lack of education, it basically diminishes the girl's ability to reject marriages. When they are illiterate, they don't have a say in the family, so that reduces their chances to reject. So they are a victim of child marriage. Second is poverty. Why poverty? Basically these daughters, they are often considered a burden and they are married at a very younger age to basically dissuade, to basically remove the liability on parents. Then comes the concept of gender inequality. Basically these girls, as they are considered burden, not boys, so they are like that the parents want to transfer their liability to others, so they are married at a young age. Then there are social customs and traditions. Basically there are various communities which view child marriage as a tradition and it perpetuates this custom across years. Then there are security reasons. Basically parents fear that their daughter may elope with somebody, or there are fears of sexual harassment and those other things, so they just want to transfer this particular responsibility by marrying them to some other family. They forget the fact that if it is a security reason, then that security reason will remain tomorrow also. You are just transferring her to some other home. If she is a security concern today, when you being the father or the mother cannot protect her, how can somebody who is being claimed to be her husband will be able to keep her secure? So if it is a security concern, that is because of her age, not because of her gender. Last is the economic factor also. Basically poor families, they see it as a way to reduce economic burden, because younger the bride, lesser are the dowry demands, so they want to just marry her so that there are lesser financial constraints on these poor families. These are some major reasons. So these reasons you will see, these are social, cultural and economic reasons. Next is the consequences. The first consequence is health risks of early marriage. Basically the girls who are married at a young age, they are more vulnerable to health issues and diseases like even HIV. Second is exposure to violence and abuse. Since these girls are at a very tender age and they have very limited status, power and maturity, so they are too vulnerable to violence and abuses of the other family. Then loss of education and economic opportunity. When you are being married at the age of 12, 13, 14, what is the age at which you will educate yourself and you will be financially empowered? Basically this concept of child marriage, it deprives these young girls of the opportunity of a meaningful work. Then cycle of gender inequality and poverty. Why so? If a girl is married today at a younger age, it leads to a vicious cycle of gender inequality. Poor health. Why? Because when she herself is not very well mature, what maturity will she pass on to her kids? If she is married at the age of 12, 13, 14, she will be pregnant in a year or so. This is the common trend as seen the concept of child marriages, and basically this is a very vicious cycle of poverty, poor health and illiteracy. Then we have maternal and child mortality risk also, because MMR, basically maternal mortality ratio, this is very high in the case of child marriage, because they are physically not mature enough to bear a child. Next, if we talk about certain measures that have been taken by the government to counter this child marriage, first is the Prevention of Child Marriage Act 2006. Basically it bans marriages for girls under 18 and boys under 21. And this is the major bone of contention why we are discussing this particular article. In my upcoming slides, I will tell you why this particular thing, that there is a difference, there is a different age for female and male. For female, you cannot marry below the age of 18. For men, it is 21. And that is the major issue why we are discussing this article today. Till now, I am just discussing the this topic of child marriage because it is very important from your GS1 as well as GS2 perspective. But the major reason why this Allahabad High Court gave a ruling to keep a uniform age 18 and 21, that we will be discussing in the upcoming slides. Second is Bal Vivah Mukt Bharat campaign. Basically, there are some 7 states who were the target. Like West Bengal, Bihar, Jharkhand, Rajasthan, Tripura, Assam and Andhra Pradesh. These are the 7 states which I even discussed in my National Family Health Survey 5 report. Right, that it is when we were talking about regional differences, that these are the states where there are more cases of child trafficking. So these were 7 states which were kept under Bal Vivah Mukt Bharat campaign, where the target was to basically eradicate child marriage. Then we have this Juvenile Justice Act of 2015. It is also basically aimed at protection and care of children who are at the risk of child marriage. Then Beti Bachao Beti Padhao scheme. This was launched from Haryana. Basically, the target was to educate the girl child, to save the girl child so that the future can be safe. Then we have National Commission for the Protection of Child Rights, NCPCR. Basically, its also major target is to create some awareness programs, cultural programs and consultations with various stakeholders to ensure that child rights are protected. Then government has also launched various child line like helplines. These are helplines 1098 where children can report their grievances. Despite all these efforts, there have always been challenges. Why we are discussing this article today is in context of this Uniform Age bone of contention in this Prohibition of Child Marriage Act 2006. When we talk about certain provisions of this provision of Prohibition of Child Marriage Act 2006, the first factor that comes to our mind is marriage age requirements. Under this particular act, basically the legal marriage age, it is set 21 for boys and 18 for girls. Any marriage which involves basically individuals below these particular ages, it is considered illegal as well as punishable. Second provision is of child marriage prohibition officers, which we know by the name of CMPOs. Basically, it authorizes state government to appoint these child marriage prohibition officers at the state or district levels. These are responsible for preventing child marriages and collecting evidences for the prosecution of various people. Third is this PCMA, it replaced the Child Marriage Restraint Act of 1929 because of various provisions which were basically outdated and which were required for the marriageable age for both boys and girls. Next is nodal officer. What are these nodal officers? The district collector, he or she serves as the nodal officer at the district level, who is responsible for overseeing the implementation of this particular act, Prohibition of Child Marriage Act 2006. Now, what are the issues in this particular act? The first issue is regarding gender-based disparity in annulment rights. Basically, when you are keeping the minimum age as 21 for men and basically 18 for women, then it is very natural that men get more time than women to annul a marriage. And that is basically the major issue. Why? Because the age is 18 for female and 21 for men. So, and basically in the case of Independent Thought versus Union of India 2017, Supreme Court, it allowed men to annul marriage till 23 years, while women, they were only allowed till 20 years. This was also basically unfair. So this is one of the major issue. Second issue is confusion over age definition. Basically this particular act, it defines 21 and 18, but this Majority Act of 1875, it basically kept 18 as the uniform age for both. So it is creating various legal confusions regarding when a male basically it can seek annulment. It is 18 or 21. Then various patriarchal notions in marriage laws. What are these patriarchal notions? They feel like the higher legal marriage age for 21, it assumes that men must be financially independent. He or this male should be the dominant one in the family, and the female who are married basically at a younger age of 18 than 21 for male, they are assumed to take care of household responsibilities only without any financial freedom. Then we have lack of effective enforcement. Basically it is not like that we don't have laws. The law is obviously saying that it is 21 and 18, but it is not restricting basically those who are forced into marriages as basically mere kids. but it is unable to act immediately due to social or financial constraints. The laws are there, but its effective implementation is not happening. Then fifth, we know basically criminalization without social protection. Basically, despite various legal bans, it is still prevalent, child marriage. You have seen basically from 23.3% in women and 17.7% in men. This is the data of National Family Health Survey also. So basically, we are just doing criminalization without social protection. We are failing to give them proper social protection so that they can basically, look for particular thing. Then strict enforcement, basically it is this criminalization without social protection is also highlighting the fact that strict enforcement, it is just leading young couples to either evade away from reporting, or it is basically keeping the concept of child marriage underground. Then we have limited time frame for annulment. I have already discussed the difference between this 21 and 18. Next is the way forward. The first way forward is obviously that it should be aligned with the Majority Act of 1875, and there should be a uniform age of 18 for male as well as female. Then we should implement the recommendations of the task force which were headed by this Jaya Jetli. Basically, it said that the legal age for women, it should be raised from 18 to 21, the same thing, and it should be aligned with men. Third thing is legal enforcement. Basically, these appointments of CMPO, Child Marriage Prohibition Officer, it should be done very strictly at the state level across the country. Then community involvement should be there. Basically, it cannot be one size fits all approach. There are certain communities who are considering it as a custom tradition. For them, it is not a taboo, but it is a something that should be praised of. So community involvement should be there. People, their grievances should be taken care of. Once they are also a part of the table on which these laws are made, certain improvements will be better. Then awareness campaigns and capacity building should be done, like Beti Bachao and Beti Padhao, because that is also leading to improvement in sex ratio across the country, as well as these MMRs and other ratios, they are also improving. Then use of technology. Basically, technology is one thing which can be implemented to impart education, to impart positivity, and to basically eradicate the dogmas, the superstitions associated with all these things. Then finally, we have also given you a practice question. You should try this question and attempt your answer in the comment box. The question says the Prohibition of Child Marriage Act specifies different legal marriage age for men and women, leading to gender disparities in annulment rights. Critically evaluate this gender-based disparity and suggest measures to ensure equality in the annulment process under Prohibition of Marriage, this Child Marriage Act, right? So basically, try to attempt this particular question and give us your answers in the comment box. Thank you. And the next article talks about Denotified Tribes. Why it has been in news? Basically, the Anthropological Survey of India and the Tribal Research Institutes across the country for the first time very comprehensively categorized 268 denotified, semi-nomadic and nomadic tribes which were thought to have never been classified before. So because of this new classification of 268 tribes, this event has been in news. When you look for the relevance of this particular topic from your prelims side, this is very relevant, as in previous years also there have been various questions on various tribes. If you look from mains perspective, under GS2, issues related to SCs and ST, it is very important. Now, what are denotified nomadic and semi-nomadic tribes? These are basically communities that were notified as being born criminals. During what? During the British regime, under a series of laws which was starting with Criminal Tribes Act of 1871. So they were considered criminals during the British era. And now what happened? These acts, they were basically repealed in 1952 during the independent India, and these communities were denotified, right? Now when these basically tribes, they are spread across SCs, STs, that is scheduled caste, scheduled tribes, other backward caste categories except few. That most of them are categorized there except few. Next, if we talk about Article 366(25), this basically categorizes various scheduled tribes but not these DNTs, that is denotified nomadic and semi-nomadic tribes. So Article 366 subclause 25, it is talking about various scheduled tribes but not DNTs. Then under Article 240, which basically asks to constitute a commission, appointment of a commission to investigate into the conditions of these particular STs and basically backward classes, it is covering many of these DNTs. So the commission formed under Article 340 to look after the conditions of various backward classes is also considering various DNTs, right? Next, if we talk about various challenges what are being faced by these particular DNTs, then the first particular challenge is there is no permanent commission with respect to these DNTs. They, like as we saw in Article 340 also, that is to look into the conditions of backward classes, not DNTs, but it is still covering various DNTs. Lack of data on caste from census, that is there is ambiguity in caste categorization across states. There is no similarity across states that what will be the data, what is the census data on these DNTs. It is different from state to state. Then there are delays in the implementation of the recommendation of IDATE commission, right? This was the commission that was set up by the government. So there are various basically issues with respect to this particular recommendations. Next is they are lacking a permanent address, and hence they are not covered under various welfare schemes of the government. Since they are not having a permanent address, they are basically nomadics. So various welfare programs that have been started by the government for the welfare of the tribes, they are not a beneficiary of those welfare programs also, be it in the education sector, health sector, nutrition sector, or social security measures. Then there is a stigma around them. Why so? Because of the criminal tag of British era. They were considered criminals during the British era, so that tag still hovers around their name. Then there is lack of basic infrastructure facilities like sanitation, healthcare and all those things, because even they are not covered under various government schemes. Then there are more than 10 crore Indians from over 1400 communities who are either basically denotified, that they are settled in various states of India, or nomadic, that they continue to be largely nomadic or semi-nomadic. So there are almost 10 crore Indians from more than 1400 communities who fall under the category of DNTs. When we talk about various measures that have been taken by the government to improve their condition, the first thing that comes to our mind is that in 2014, basically Government of India had set up National Commission for Denotified Nomadic and Semi-Nomadic Tribes, that is DNTs. And what was the purpose of this IDATE commission? That it was constituted for a period of 3 years. Basically, it had the provision to prepare a state-wise list of caste belonging to these DNTs and basically look for their progress. Then we have this seed scheme of 2022. It was meant for scholarship, economic empowerment, housing and healthcare for these tribes, these DNTs. So this seed scheme is again very important. Then government also constituted a development and welfare board for the denotified nomadic and semi-nomadic communities. This was another board that was developed by the government to look after their conditions, to improve their conditions. How can they be a part of mainstream India? So these are certain initiatives from government side. Once you're preparing such a topic, under the GS2 social justice part, you can get a question on DNTs, exclusive question on DNTs, and in prelims there are highest chances of this question being asked. We have given you a practice question also. Every year a month-long ecologically important campaign, or you say festival, is being held during which certain communities, tribes plant saplings of fruit-bearing trees. Which of the following are such communities? So we are looking forward to your answer in the comment box. Do make this your habit of commenting the answers, because this way you will be able to cover certain questions. Thank you. And the next article talks about parole. Basically, this is in news because of the temporary release of convict Gurmeet Ram Rahim from prison on a 30 days parole. You might have seen in the recent past, UPSC also asked about interim government's concept in UPSC prelims. It may be asking about anticipatory bail. So these concepts are very important from the topic of polity in your prelims. So you should understand what parole exactly is. In your mains part, this is very important under government policies and interventions. So basically, what is a parole? It is the temporary release of a prisoner before completing their sentence, and it is subject to certain conditions also, which for example, it can be granted on the humanitarian ground or in the emergency grounds, and it sometimes also acts as rehabilitative measure. And you should understand that it is a privilege, not a right. This is very important. Depending upon the state and the jurisdiction, parole is basically granted either by the court or the jail authorities with prior permission of the state. First state will grant the permission, then either the court or the jail authorities will grant parole. It is governed by state prison rules under Prisons Act of 1894. There are certain conditions for granting parole. These basically parole guidelines, they are formulated by the state governments. Certain conditions are the convict, he or she should show good behavior, then must have served at least 1 year in jail, no criminal activities during the period of the previous parole, then minimum of 6 months between two paroles, right? Then there are few exemptions also. Those who are convicted in crimes against the state or a threat to national security will not basically getting the parole. Also, people of convicted of murder, rape and some other heinous crimes, they are also not allowed for the concept of parole. What is the significance of parole? The first significance is that it is a tool of social rehabilitation. Basically, if you are showing good behavior, you are showing improvement in your overall etiquettes and everything, then it is kind socially rehabilitating, that you may get a part to be of mainstream society again. Next is, it also helps in decongesting jails. We already know the number of adult trials in our country, so basically it sometimes helps to decongest jails when some people, because of their good behavior and all, they are given parole. When we are talking about parole, you should also understand the concept of furlough. Somewhat similar. It basically means granting leave of absence for a specified period of time to a convict from prison. It is conditional release and is granted as a good conduct remission. The right to be released on furlough is a substantial and legal right. Parole was not a right, it was basically a privilege, but furlough is a legal right of the prisoner, and basically he or she cannot be denied this furlough if it is permissible under the law, and it is granted by cannot be denied if it is permissible under the law. So this is the condition, this is the difference between parole and furlough, and it is basically granted by the Deputy Inspector General of Prisons for a maximum of 14 days. Right. Next, you should also understand the concept of bail. What is bail? Bail is basically conditional release of a person accused of a crime for an amount pledged for the appearance of the accused when the same is due in court. There are various types of bails. One of them is anticipatory bail, which is often in news. The person who is basically paying the money on behalf of the person who was accused, he or she acts as the surety. Getting bail is one of the rights of the accused in a civil case, but it is the discretion of the authorities granting bail in case of a criminal case. An accused can basically apply for the bail for pursuance of his fundamental rights under Article 21. So this is again a right, not a privilege. There are various challenges also associated with the concept of parole. Basically, a prisoner's good conduct in prison cannot guarantee good behavior after release. In the past also, there were prisoners who committed crimes on their parole, like in this Sai Banna versus State of Karnataka, a person who was in prison for the murder of his first wife committed the murder of the second wife while he was in parole. The last, another big challenge associated with the concept of parole is that it is being misused by the rich and the influential. Why so? Various high profile prisoners, they are basically taking parole very frequently. The case in news is of Sanjay Dutt's parole in 1993 Bombay blast case. So these are certain challenges that are there with parole. We have also given you a practice question that with reference to India, consider the following statements. When a prisoner makes out a sufficient case, parole cannot be denied to such prisoner because it becomes a matter of his or right. State governments have their own prisoner release on parole rules. We would appreciate your answer in the comment box so that it can become your habit and you can basically understand the lecture and attempt these questions. Thank you. And the last article talks about Deepseek. What is Deepseek? Basically, Chinese startup Deepseek, it has launched various AI models. AI means artificial intelligence. When you look for the relevance of this particular topic, from prelims perspective, this will fall under your current affairs science part, and in your mains under GS3 science and technology. Basically, why it has been in news? Because Deepseek's AI assistant, it became the most downloaded free app of Apple's iPhone store, and which basically crashed many of the tech stocks on Wall Street. And now people are very eager to see if Deepseek can match OpenAI's ChatGPT at a lower cost. So what is basically artificial intelligence? Set of various technologies that enable computers to perform tasks that normally require human intelligence. This is an era of artificial intelligence. You will find the use of artificial intelligence in every field, starting from healthcare to your banking sector and everywhere. Now basically next important question is, what is Deepseek? It is basically a Chinese AI startup that has developed an AI chatbot competing with OpenAI's ChatGPT. It aims to advance China's AI capabilities but follows governmental censorship on politically sensitive topics. It was founded by Liang Wenfeng in 2023. This Liang Wenfeng, he has already established basically Chinese qualitative hedge fund, which was called High Flare in 2015, which later pivoted into Deepseek. So it has been established by Liang Wenfeng, but this person is following governmental politically censorship. Now when we compare ChatGPT with Deepseek AI, the core focus of Deepseek AI is it initially focused on quantitative finance but shifted to AI research with the aim of building advanced model and working towards AGI. When we talk about ChatGPT, its primary focus is natural language processing and conversational AI. ChatGPT is basically designed to assist with tasks such as answering questions, basically performing various interactive conversations. When we look for the cost, Deepseek has been established at a very low cost. It has been basically produced at a cost of $5.5 million, which is not even 1/10 of the ChatGPT cost, which was estimated around $100 million. So this is again a major challenge. Now when we talk about various challenges associated with AI or particular Deepseek, first is of censorship and government control. As I've already mentioned that this particular Deepseek, it is following the government censorship guidelines regarding various political things. So it can basically lead to potential content censorship and limitation on the freedom of speech. Second is lack of industry experience. Most of the people who are there in this startup, they are PhD students with limited industrial experience, which could easily pose a challenge for developing consumer facing applications. Third is data privacy and security. Being a Chinese app, the sensitive nature of the data and the AI driven system, it will be very challenging to basically cope up with the emerging challenges. Next is outdated data and facts. This is again a major challenge because both Deepseek AI and ChatGPT, they face the challenges of outdated data as they rely on training databases. You will often find giving commands to ChatGPT and getting repetitive wrong answers, right? Now what can be the way ahead? Way ahead can be basically balancing censorship and ethics. If you are following the government censorship on political topics, you should be ethically sound at the same time. It should not target any particular political party. Then there should be a balance of user trust and data security. Users trust must be maintained, not at the cost of data security, and vice versa. Both should strike a fine balance basically, and the security measures must be taken so that users trust in the system can be maintained more. Next, strategic partnership. Basically Deepseek, it will have to collaborate with certain global tech firms, and then only it can basically gain expertise. It's those PhD students who are a part of this startup, they can get more control and more expertise from the talent pool. Then data updation is another way forward because it involves regular updates, real-time data integration, and continuous AI model reframing. So these things will be needed to be in fine tune with the updating challenges and upcoming instances. Now we have also framed a practice question from this particular thing, and this is basically a question which was asked in UPSC Prelims 2020. We would love to see your comment in the comment box. With the present state of development, artificial intelligence can effectively do which of the following? Bring down electricity consumption in industrial units, create meaningful short stories and songs, disease diagnosis, text to speech conversion, wireless transmission of electrical energy. So you should comment the answer in the comment box regarding the application of artificial intelligence. So that's all for today's video. If you like the video, please like it, share it, and comment on the same. Thank you.